Greetings, fellow ENMU students, and of course, Professor Green. My name is Michael Pirovano, and today I'm going to be going into detail on the ethics behind the reasonable person standard. I apologize for not having a video of myself presenting this material to you. My webcam has been splitting my face in weird places when I try to record. My guess is that there's a crack somewhere. However, I've provided a picture of myself, which you'll find in the upper right-hand corner, which serves as a visual aid should you want to put a face to this silky smooth voice of mine. Of course, if we're going to talk about the reasonable person standard, it would help for you to know what that is. So, the reasonable person standard is this hypothetical concept used in law, particularly in tort and criminal law, and it describes a person. Now, this imaginary person is used as a standard of comparison in determining liability because he or she is considered to be reasonable. So, what constitutes reasonable? Well, we make a few assumptions. We assume that they live in the same society or culture of the person whose liability is being determined lives in. We also assume that they exercise the average amount of care, judgment, and skill someone living in that society could reasonably be expected to exercise. These assumptions are essentially a way of defining or pinpointing the concept of the average person, the average Joe, someone with a societal baseline of caution and judgment. Now, I won't spend too much time going into detail on the history of the reasonable person standard, but I'm not going to gloss over one of the coolest parts either. Another name for this standard is the man on the CLAPHAM omnibus. The man on the CLAPHAM omnibus. It sounds like the title of a play we were forced to read in high school, doesn't it? Well, that's probably because the name goes all the way back to the United Kingdom in the late 1800s, early 1900s. The year it was first used has been debated a little bit. Some point to a case in 1903, while others argue that it can be traced back to 1871. The actual bare-bones concept of defining a reasonable person in a legal context was actually first used around 1837. But this odd kind of name likely came from the journalist Walter Bagot, who wrote that public opinion is the opinion of the bald-headed man on the back of the omnibus, an omnibus being a reference to the term for a standard commuter bus at the time. The reference to male pattern baldness I may never understand, but he's essentially saying that public opinion is the opinion of the person who participates in some of society's most common activities, such as riding the bus. Going along with this, when the concept was finally reviewed by the Supreme Court of the United Kingdom, it was presented as being the action, judgment, reaction, etc. to an event or situation if you picked one average reasonable person from one average commuter bus on any given day. And it would be wrong to try to squeeze some evidence or grounds for accusations based on something that any reasonable person might do. But a lot of what's been written about this standard has used the words reasonable and average interchangeably, and I want to point out early on that that's not something they should be doing. Complicated as it sounds, sometimes the reasonable explanation of the average man would be to react unreasonably. So let's say, for instance, and purely hypothetically, I should add that someone breaks into your home. Let's say it's the middle of the night and you hear some rustling going on downstairs. So you take a baseball bat or whatever you have nearby and creep downstairs, and you see a guy shoveling your stuff into a bag. So now the fight or flight response is triggered. You pick fight, you knock him around with the bat for a second, and a gun comes tumbling out of his pocket. If you pick up that gun, whoever's breaking into your home is now totally disarmed. If we solely follow reason in this instant, you know that you have the upper hand and it's game over for your burglar. The average person, though, is not getting into enough physical confrontations to be so level-headed in these types of situations. The average person may very well react in that moment by shooting the burglar. So you see, it's not the most reasonable reaction, but in that situation it is reasonable to believe that it's something the average person might do. So how do you prosecute that? Well, let's take a look at some of the ways this concept is applied. So in the business world, some common issues for the reasonable person standard can be found in cases which involve a loss of some sort, which I suppose is many or most cases, but this is typically a financial loss in which an unforeseen consequence or effect cost a person or company a lot of money, but it could also be losing face with the public. So for example, a recent example with Pepsi, the Pepsi commercial, right? Went terribly. Would the average person, though, have foreseen the massive PR fiasco using the growing tension between law enforcement and people or communities of color to push a product? Would they have foreseen the kind of backlash that would cause? So it's commonly used when, also used when creating or interpreting business contracts. So is this contract worded clearly enough for a reasonable person on both ends of the aisle to understand without misinterpretation? And it's really not hard to imagine a number of scenarios where the reasonable person standard might be used, but one of the running themes is that the use is towards this idea of personal judgment. Was the person whose judgment caused some level of harm to the other party using the same judgment expected of a reasonable person? It's also not hard to imagine how a concept so broad and difficult to define can be used unethically in the favor of one party or another. The main source of unethical shenanigans we see with the reasonable person standard is when someone tries to use an objective standard subjectively. So this is an inherently objective standard. It doesn't represent any single person, but rather a broader representation of the average reasonable person within a given community. However, any attorney looking to swing a case in his or her favor will apply the standard subjectively to try to convince the jury, saying, hey, I'm a reasonable person, you're a reasonable person, and this is what we do, right? And there's a lot of room for unethical behavior within that in arguing the case itself. But on top of that, that subjective use is something that can be used to justify unethical behavior. So for example, hey, I met with a lawyer representing the Russian government for opposition research. Any reasonable person would want to get their hands on some of that, right? Of course, that specific argument hasn't been used in court yet. But almost every case of trying to use the reasonable person standard to try to justify unethical behavior is very similar at its core. The argument is very nearly always made in some way, shape, or form that the action or behavior being defended was the result of a person or party acting as any reasonable person would. So a huge example that we see in the business world is with sexual harassment. Now, our textbook states that to establish sexual harassment, an employee must understand the definition of a hostile work environment for which 3 criteria must be met. The conduct was unwelcome, the conduct was severe, pervasive, and regarded by the claimant as so hostile or offensive as to alter his or her conditions of employment. So I want to focus on this for a second to kind of examine some of the ethical dimensions at play here, because there are quite a few. So let's take a second and set the scene. Let's say you're a female working at an insurance company, and you've gone out to dinner with your male superior in a group setting on a number of occasions, and you kept things strictly professional. But over time, your superior has made a few comments that set off a few alarms in your head, and then one day a position opens up. Now this position would be a promotion for you, and suddenly your superior wants to meet with you over dinner one-on-one, claiming that he wants to discuss it with you, but something definitely feels off. So after making a few requests for a one-on-one dinner, you finally give him that firm, hard no. And a week later, you learn that your position is being eliminated, a direct decision of your superior. End scene, blackout, exit stage left. So let's start by identifying the various ethical alarm bells we set off here. And we should note that we're assuming your superior knew good and well what he was doing, knew it was wrong, and did it anyway. You could argue that the uncomfortable comments are just sleazy and don't have much of a deeper ethical implication beyond that. Your superior's personal ethics, unfortunately, can probably be pretty easily defended in this case. If the comments were uncomfortable, there's a good chance they were not very direct, and you can chalk that up to ignorance. On an ethical level, however, if your employer truly saw nothing wrong with this, the comments would have set off his personal set of ethical alarm bells. And personal ethics being something you have to kind of take into account in the greater context of business ethics, as we've learned. But then there's the request for the one-on-one dinner. Now this is where I can see an attorney having to really work the reasonable person standard in your superior's favor. The legal argument would be that under the reasonable person standard, it makes perfect sense for your superior to want to speak privately with you about the position so as not to make other employees jealous or all rush in to throw their names in the hat, whatever BS excuse you want to go with. But let's talk about the ethics here. Morally, a quid pro quo of this nature is indefensible. I personally fail to believe that any reasonable person carries a set of morals that would justify something like this. The principles behind your superior's actions are highly compromised here. Principles, as defined in our textbook, being specific and pervasive boundaries that should not be violated. So under this assumption that he knew what he was doing, it would be pretty easy for your attorney to argue that any reasonable person with the average sense of judgment would at the very least recognize these boundaries. However, if it was successfully argued that the superior was acting reasonably in the interest of maintaining discretion regarding an internal promotion, there would be no principles violated by the action. Then we have values. So the values in question in this scenario are similar to the principles in question. It's a matter of doing what you feel is right and not what you know is wrong. A major value in the world of business is integrity. And this is where I feel an attorney could accidentally back your superior into a corner. Because if they take the stance that your employer was just following his moral compass and that they're this upstanding, ethical individual who would never want to rock the company boat with other employees by publicly discussing an internal promotion, if they push too far in that direction, then we start to wonder if it could be reasonably expected of someone who holds themselves in such high regards in terms of ethics and ethical standards, if we wonder if that person wouldn't at least be able to acknowledge how their actions could be perceived as unethical when the perspective is shifted, is switched. So they really risk losing the jury on this, especially if you have a smart lawyer who can milk that and snowball it into the final ethical alarm bell, which is, of course, eliminating your position. So at its core, there's really no way to see this as ethical. This is retaliation, plain and simple. Assuming your superior hasn't been backed into a corner by this point, this is actually something that's fairly easy to defend. You can, again, BS any excuse you want to justify eliminating the position, but as I said before, push too hard in defense of your superior acting on his morals, and it becomes hard to believe that he wouldn't see how this could be interpreted as unethical and retaliatory. So this is the reasonable person's standard's last stand. Really, the only thing you have left to argue with the standard is that the reasonable person would not have the foresight to identify this, or that the reasonable person would act in the best interests of the company and eliminate the position based on whatever phony justifications they cook up. So I hope from this example you can see how the reasonable person standard can play such a complex role in business ethics and has some pretty severe implications. You get a good enough lawyer and the standard could be manipulated subjectively to work in your favor on a wide range of situations. It is genuinely a powerful and to a large extent terrifying tool, and it can be used to do immense good or bad. As I see it, it's a very good thing for our legal system to have in place. I think it's a very necessary standard of comparison when it comes to assessing someone's actions and the ethics behind them. At the same time, it's very easy to manipulate, to pose the standard subjectively rather than objectively. So I hope this presentation was informative. I hope I'm leaving you with some food for thought. I hope you've learned a little about love and a lot about yourself. I hope you're left inspired. Maybe you're finally ready to start that novel you've been meaning to write. Maybe I've inspired you to reduce, reuse, and recycle, to be kind and rewind, to finally tell your mother that you're 29 years old and can make decisions for yourself and will get married when you're good and ready. But if I've accomplished nothing else with this presentation, I hope that you'll at least keep the reasonable person standard in mind the next time you hear about a legal case in the news. So I hope you've all enjoyed this, and I'd like to thank you all for watching.